Okay, so welcome to the second class. I hope I'm audible.
Good evening, sir.
Good evening, Akash. And yes, rest of the participants. Okay, so without wasting any time, let's start the class. So just a reminder, what we discussed yesterday, which are the potential areas for asking questions. There can be a question on universal adult suffrage. Okay, there can be a question about election commissions, delimitation. Now, there can be question on yes, the expenses, okay. Then important terms, that is CEO, DEO, returning officers, presiding officers, polling officers. Then EVM and VVPAT, there can be a question. Now, we talked about various apps. So even when we talk about the sweep with respect to what information for the voters, C-Vigil, Suvidha, Encore. Then we talked about Saksham, we talked about Garuda. So all these are potential questions, yes, which can be asked by UPSC. Now, then we talked about the important areas and locations. So, West Bank, Gaza Strip, Rafah crossing, important, Sinai Peninsula. Then we are talking about two important refugee camps, Jenin and Tulkaram. Then Jordan and important areas like Sea of Galilee, Golan Heights, Jordan River, Gulf of Aqaba, also known as Gulf of Elat. So these were the areas that we discussed, and all these are the potential areas where UPSC can frame questions. Now, one more clarification with respect to the query. First of all, the people who are convicted means the people who are sentenced to jail or are in jail after sentencing by the court, they cannot vote. They cannot vote. But there was a little confusion about under trials who are accused, which are not yet convicted. So I clarified with my student who is now DM in East Delhi. So he served as a election manager in the state of Mizoram. So he talked about the practicality. He stated that there are certain considerations. Now, for example, under trials who are released on bail, who are not in custody, they can vote. Okay, so please note down what he explained. Just note down. So under trials who are accused, under trials who are accused but not in custody, are out on bail, they can vote. I hope this is very clear now. Now, second is the people who can be arrested in the form of preventive detention. Okay, that means they have not committed a crime, but the police is going to arrest them so that they are not going to commit the crime. So the people under preventive detention, they can also vote because they have not yet committed a crime. For them, there is a provision of postal ballot. Okay, so I hope very clear. So that means the people who are under preventive detention, who have not yet conducted a crime, yes, but can commit a crime. So those people who are arrested by the police, they can also be allowed to vote through postal ballot. So these are the major changes that you can add on. But one thing is sure, convicts who are in jail, sentenced by the court, they cannot vote at all. Now, for example, there was one more query with respect to, for example, if Mr. Arvind Kejriwal is in custody, so whether he can vote or not. So again, it depends upon the permission by the Supreme Court, depends upon the permission even by the ED itself. Okay, so these are the certain. So yes, UAPA. So UAPA just charges of maybe preventive detention. They have not committed a crime, but can belong to an organization which has a previous record of committing a crime. So if they are arrested under UAPA, but that person himself has not committed a crime, will still be allowed to vote. Okay, very clear. So let's move ahead. So now, okay, let's cover various interesting things today, linked with police, linked with what investigations, linked with what even judiciary, subordinate judiciary. Now, many of you are reading what M. Lakshmikant type of books or polity. You mostly focus on Supreme Court and High Court. But very few of you know about the subordinate courts and what type of courts, what type of names, whatever judges there are there. The nomenclature being followed by these courts, many of the students are not knowing. So major focus area will be subordinate courts, not the high courts and supreme courts. Okay, so here let's start with. Now, when we talk about the election, yes, when we talk about election, one more thing comes into picture: security deposit. Now, I was talking about, yes, there's a security deposit of at least 25,000 rupees for the Lok Sabha election and 10,000 rupees for the Vidhan Sabha election for the general category candidate, and even OBCs are included within the general category. Okay. So there's an exemption for paying the half of the money only for the SCs and ST candidate. So half of the money. So security deposit. Now, why security deposit? Because the purpose is to encourage only the sincere candidates. Sincere candidates to encourage. Now, but there can be chances if the candidate is not sincere, is not able to get 1/6 of the valid votes polled, then in those cases, the security deposit will be lost by the candidate or will be forfeited by the authority. Clear? So that means forfeiture means if a candidate not getting minimum of 1/6, okay, minimum 1/6 of valid votes polled. That means if the candidates get less than 1/6 of valid vote polls, in that scenario, the security deposit is forfeited by the candidate. We call in Hindi zamanat zabt ho gayi. Yes. Okay, it's very simple term that we use, zamanat zabt. Now, but there are certain cases where the security deposit can be returned. Now, this is an area where UPSC can put statements. Now, let's properly focus in what terms, on what conditions security deposit can be returned by the Election Commission. Now, let's see now. Now, if the name of the candidate is not shown in the list of the contested candidates, yes, that means in the EVM, the name is not visible. Maybe the person has withdrawn the candidature late. Okay. Maybe that candidature is cancelled by the Election Commission and the name is not visible, but that person, while filing the nomination, initially submitted the security deposit. In that scenario, security deposit will be returned. Okay, so it's clearly written, if the name of the candidate not shown in the list of contesting candidates, it means either his name is being rejected by Election Commission or has withdrawn the candidature. So here, the returning of the money will apply. Now further, if the candidate dies before voting starts, so if the person is dying, he or she may be very happy filing the nomination paper, but that happiness is very short-lived, not able to contest, dying before the actual voting starts. So in that scenario, also the money will be returned. Now, naturally, if the candidate wins the election, so naturally the security deposit will be returned. Now further, now if the candidate does not win, but secures more than 1/6 of the valid vote polls, that means the person has secured more than 1/6 of valid vote polls. In that scenario also, security money will be returned. And this is very interesting. If the candidate wins the election, but still not able to get 1/6 of the valid vote polls, so in what condition this will happen? Candidate is winning the election, but still not able to get 1/6 of the valid vote polls. So in what condition will this happen?
Low turnout.
Low turnout can be, or
if only one candidate is there.
no, or there can be many candidates who are cutting into each other votes.
Yes, sir.
For example, maximum.
Undercutting. Yeah.
Pardon, you can speak.
Undercutting.
Undercutting, yes. For example, the maximum people who can be included in what multiple of EVMs can be 384 candidates. So, for example, assuming if the 300 candidates are there, naturally there are more chances that very less people will be reaching this mark, 1/6. Okay, so there can be a possibility even the winning candidate may not be getting, because the margin can be 1, 2, 2, 2, 3, 3, 4, or 5 votes among the candidates. Yes, okay, so it can be a possibility. So that means in such 5 scenarios, the security money will be returned. So these are the statements which the UPSC can put. Now let's talk about the corrupt practices. There comes a term called corrupt practices where they are being mentioned. Section 123(3) of RPA 1951, corrupt practices. Now, which are these corrupt practices? Now, these corrupt practices include, yes, bribe, okay, undue influence, false information, and definitely promotion or attempted promotion of feeling of hatred on the basis of caste or religion or region, whatever the conditions. So these are corrupt practices. That means inducement of money, force, threat, or hatred. These are corrupt practices. Now, all these come within section 123. But now when we talk about 123, when we see the subsections, so section 123(2) deals with undue influence. So undue influence means that can be positive also, positive in terms of monetary, inducing the people, or can be threat also, forcing the people not to go for voting. So it can be, so in either case, whether it can be inducing the form of money or monetary benefits or a threat, both of these are termed as undue influence. Further, section 123A, this is on the basis of the discrimination, hatred, or enmity promoted on the basis of caste, religion, or class, or maybe race, all these type of things. And there's one more thing, 123(4), which extends the meaning of corrupt practices or a range of corrupt practices to also include intentional publication of false information, either through electronic media or through print media, or with respect to your opponents or the opposite candidates. Yes, any false information. So all these will be coming within what? Corrupt practices. So corrupt practices, I hope you can easily recall. Okay, undue influence, bribery, hatred, and within the corrupt practices, one more thing is intentional publication of false information with respect to your opponents or candidates. Now comes to the picture what certain terms which are little confusing with respect to what the actions by the judiciary and the police. So let's start with a term called cognizable offense. Now, cognizable offense is a serious offense in which the police can arrest without a warrant. So cognizable is a serious offense in which the police can arrest without a warrant. For example, if a robbery is taking place and police knows, immediately rushes and catches the people, arrest the people. Okay, or maybe a murder is taking place, information, now the murderer is still at the murder site, can be arrested by the police. Clear? So that means the cognizable offense means serious offenses where the police can arrest without a warrant. So this is a serious offense. So these are the serious offenses. So police can take immediate action without the permission from the court. Now, non-cognizable offense means permission of the court is required. Means, first of all, the warrant has to be issued through the court. So non-cognizable or of what lesser serious nature. For example, you and we are fighting, and finally I am what have hurt you in a fight, yes, or you may have hurt in a fight. I cannot hurt you because I'm an old person now in comparison to you. You can easily hurt me. So in that scenario, if I'm going to complain against you, the police will not be immediately filing maybe an FIR or may not be also going to issue an arrest warrant because that is not in the power of the police. Or if I'm giving you intimidation or threat, or if I am putting something of false information, putting a case of defamation or defaming you in the society. So these type of cases are coming under non-cognizable. So if I am approaching a police with a complaint, then police will be recording this not in the FIR register, but in the general diary as an informal complaint. But the police will be advising me, if you want to get the person arrested, get the order, yes, get the arrest order from the court. Okay, so that means it has to be done through judicial magistrate then. Now, so non-cognizable means the category of offense in which neither the the police can neither register the FIR nor can investigate or effect arrest without the express permission from the court. So permission of the court is required in case of non-cognizable. So non-cognizable means maybe enmity or maybe a fight or a defamation or hurting each other. All these type of things are coming under what? Non-cognizable. So here, what is required? What is required here is permission from the court. So these mostly include minor offenses like abusing each other, minor scuffles without injuries, intimidation, etc. Now, your complaint shall be referred to the concerned police station where you may be called for further clarification. So what the police will be doing in this non-cognizable offense case, the police maintains a general diary, which is also mentioned as NC, non-cognizable. Okay. So here, so hence the police maintain a general diary, which is called NC, that is non-cognizable, in which if you are going to complain will be entered, not as an FIR, but a general entry in general diary. Clear? General entry. Now, the police is not empowered to initiate action in such matters without the directions of the court. So police will be advising if you want to formally get the things done, so get the order from the court of arrest, warrant from the court itself. Okay. Very clear? So then what will you be doing? You will be calling your lawyer and now filing maybe a petition in the court to get the warrant issued. Okay, then the police will be taking the action. Very clear? Non-cognizable. So cognizable means serious, non-cognizable means non-serious. But here it's little confusing. Cognizable, though serious, police can arrest without a warrant. Non-cognizable, less serious, police cannot arrest without a warrant. Very clear? Similarly, let's talk about another term that's called compoundable offense. Now, compoundable offense means where, so again, here compoundable offense means less serious nature. So again, less serious. These are less serious. Now, in which both the parties agree, or maybe the person who has initially filed the complaint agree to withdraw the complaint through mutual settlement. Okay, so compoundable means of lesser serious nature where the party or the aggrieved person is willing to withdraw the case. Very clear? So now, so a compoundable offense is an offense in which the complainant can enter into a compromise with the accused and withdraw the case. For example, if somebody are in the fight and finally say pardon to each other, then it's okay. Okay. For example, if somebody has defamed anyone and now finally regret, may seek a pardon, public pardon. Or maybe the person is harassing someone, but in the front of the entire community, now ultimately say pardon to everyone. So in that scenario, if the society comes forward to settle the issue amicably, hence the cases can be withdrawn. So compoundable offense of less serious nature where the cases can be withdrawn if the person who is aggrieved withdraws the complaint. Now, when I talk about the next, the non-compoundable offense. The non-compoundable offense is of serious nature where there has to be trial by court. The case cannot be withdrawn once filed. The case cannot be withdrawn. So these are of serious nature. So there will be trial by court. So non-compoundable is serious nature. Trial by court is necessary. Cases cannot be withdrawn once filed. So all the offenses except those mentioned, so there's no requirement of mentioning or learning these sections. So these offenses are considered more severe and have greater impact to society. Hence, they cannot be settled out of court. Cannot be settled. So we know the serious offenses like robbery, murder, rape, terrorism, all these require what? Court's intervention. These cannot be withdrawn. So very clear? So when we talk cognizable offenses are the serious offenses where the police can arrest without a warrant. Non-cognizable are less serious, but the police requires a warrant. Compoundable offenses are less serious where the party, if agrees to withdraw the case, can be done. But when we talk about non-compoundable means serious, trial by court is necessary. So all these terms are a little confusing, can be put as statements by UPSC. Now, so all these ultimately boils down to what? FIR, first information report. So let's see some of the key points of FIR. So the police are not filing FIR. So what is the remedy? Okay, finally, whether the writ can be filed in case of not filing an FIR. So writ and which writ can be filed. So let's see. Now we'll talk about the FIR. So what type of offense? FIR is required. So cognizable offense, that is serious offense. Okay, so serious offenses and FIR is required. So report pertaining to the occurrence of the cognizable offense received at the police station is called FIR, first information report. Now, since it is the first information report about a cognizable or a serious offense, it is called first information. That means first time the police is able to hear about that from somebody or maybe the person who is directly aggrieved. Yes, the first information report. So on the receipt of this information, police register the report in the FIR register, not in the general diary, but FIR register directly. Now the thing to note here is there a definition of FIR given in IPC, CRPC? No, there's no definition given. So this is again a statement which is important. The term FIR is not defined in IPC or the CRPC, but the IPC is mentioned where, sorry, FIR is mentioned where in the police regulations and rules. Okay, so inform police regulation and rules. So FIR is mentioned in the police regulations and the rules, not given as a definition in IPC, CRPC. Now, There are certain exceptions while filing FIR. Again, many times the court case is also given, or the case is also given by Supreme Court as statement. So here, the Supreme Court ruling in the case of Lalita Kumari versus Government of Uttar Pradesh held that FIR registration is mandatory for cognizable offences. That means it's mandatory. So if the police personnel is not filing an FIR in the cognizable cases, so that is a crime committed by the police. So there will be action by the against the police personnel. Okay, but there are certain additions here. Additionally, it emphasized that in certain cases, a preliminary inquiry may be necessary before registering an FIR. For example, if there's a crime happened, which is a violent crime, which is a murder, which can be a rape, which can be maybe a robbery, definitely the police has to file an FIR immediately. But there are certain cases where the police can do a pre-verification first and then can file an FIR. So here we are talking about pre-verification. Pre-verification. For example, in the case of matrimonial and family disputes. So in the case of matrimonial and family disputes, the police should be calling both the parties in the dispute, okay, getting the feel of the situation, can understand both the parties' grievances, then if required, if that is amounting to cognizable offense, then can file an FIR. Very clear? Not immediately. So the police has to listen to both the parties. Similarly, commercial offenses. So commercial offenses can be maybe a business fraud, okay, or maybe a case of corruption. Yes. So again, has to listen to both the parties, and if there is a cognizable offense which comes out, then the FIR can be filed. Then comes to the picture, medical negligence. Now, if a person dies under the care of a hospital or maybe after operation, and now the patient accused the doctors, or the patient family accuses the doctor of negligence, it has to be verified first. It has to be verified first. Okay. So pre-verification is required. So pre-verification is required first. Now, corruption cases, yes, corruption cases. So you cannot put a blame that this person is corrupt. Yes. Okay. So you have to first of all prove it, and the police is supposed to listen to the person under question also. Okay. So both the parties. So corruption cases. And now there can be cases where there can be filing of the FIR quite late. For example, there have been cases where there is issue of rape, but a girl, due to the fear of the family, the fear of the so-called honor, yes, created by the society, have not immediately filed an FIR, but now approaching the police after 3 months or 6 months, okay, after gaining courage. So that means cases where there is an abnormal delay in initiating criminal prosecution, for example, or months delay in reporting the matter without satisfactorily explaining the reasons for delay. So again, in those cases, the police has to pre-verify and then file an FIR. Very clear? But this preliminary inquiry must be completed within 7 days.
Sir, I have one question.
Yes, please.
Sir, in case of FIR, it can be registered in any police station or like the nearby police station of that crime.
So that what you are saying is where it can be registered in any police station is a concept of zero FIR.
Okay.
Okay. So that will coming a little later. Clear?
Okay, sir.
Okay. So, but I hope this FIR is clear till now. Now, FIR only for the cognizable offense. It's must for the police personnel to file an FIR if that is the cognizable offense. But there are certain additional safeguards for pre-verification also in such matters as we have discussed. Okay, which was put by the. Okay, yes, Harsh, you can speak.
सर नहीं तो नियर बाय आपका जो थाना और डिवीजन पड़ता है उसी में आप रजिस्टर करा सकते हो ना?
नहीं, जीरो FIR तो कहीं भी करा सकते हो.
नहीं, जीरो नहीं, वैसे तो सर पुलिस कहते हैं ना कि हमारे डिवीजन में नहीं आ रहा, ये हमारे थाने
यस सर,
में.
जैसे
अब अगर नहीं आ रहा है तो आप पड़ोस में चले जाओ, जीरो FIR रजिस्टर करा दो.
हाँ सर, जैसे थेफ्ट के केस में लाइक वो बोलते हैं कि जो मतलब जो एक्चुअली जो क्राइम वाला के लोकेशन वाला आपका स्टेशन है, यू हैव टू रजिस्टर देयर ओनली, लाइक इट डजंट कम इन आवर जुरिसडिक्शन.
हाँ, नहीं, वो टालने के लिए कह सकते हैं, वो टालने के लिए कह सकते हैं, बट देयर फॉर एग्जांपल जीरो FIR कॉन्सेप्ट केम आफ्टर फॉर विद रिस्पेक्ट टू द सीरियस क्राइम्स, है ना. Okay, but now it has been extended to other areas, other forms of crimes also, including theft and robbery, all these type of things. Many times the police to ultimately show that their circle or their police station have got a lower crime rate, they try to delay the filing of the FIRs. Okay, so that's why they say it's not coming in our area. So if that is the issue, so you can approach any police station. Okay? Or if that police station has got an insistence that it has to be done here itself, and still if the police is not doing it, then there are other methods to approach different authorities in different manner. So we are going to talk about that a little later. So now, who can file an FIR in police station? Who is the police officer responsible? Definitely the SHO, definitely the police inspector there, definitely the assistant sub-inspector there. Okay, that means even the head constable can also file. Just a constable cannot. So whoever senior is there at the time of the duty, because many times the police people are on tour, yes, or maybe or they're visiting their respective locations. Okay, okay, in terms of what roaming the area they are controlling with respect to police station. So who is responsible? Definitely, first of all, the senior police, most police officer available in the police station at any point of time. Now, if the SHO inspector is not present, so a sub-inspector or a head constable. Okay, so a person below the head constable, that person cannot register an FIR. So maximum it can be a head constable. Now, what to do if the police station refuses to register an FIR? So what are the remedies? Let's see. So in all cognizable offenses, first of all, it is mandatory on the part of the police to register an FIR. It is mandatory. Now, so as an Indian citizen, you have the right to file an FIR for cognizable offense, and a police officer who refuses to lodge the FIR is now punishable. So there's a punishment for the police personnel. That means a police person can be punished for neglecting the work or duty. Now, the Supreme Court has stated that the police officer will be liable for prosecution. Now, what is the next step that you can do? Approach the higher authority. Okay, so approach the superintendent of police with the application. If now the SP thinks that the matter requires filing or FIR because it is a cognizable offense, can either do himself or herself also, or can ask the police station to file an FIR now. Instruct. Now, if the senior police officer is not doing it, or entire police system is working against a person who want to file an FIR, so what can be done? This person can, with the help of a lawyer, can directly approach the judicial magistrate. So judicial magistrate is a magistrate at a below district level. Okay, so district level, the district court. So judicial magistrate sits at a below, that is maybe a taluka level or a block level. Yes. So judicial magistrate, complaint to a judicial magistrate. Now, if that is also not working, so what is the last legal remedy? Legal remedy is now you directly approach the High Court and ask for filing of a writ. Now writ. So which writ will come into picture? So which writ will come into picture?
Prohibit.
So mandamus.
Because
Command.
that mandamus is going to command the authority to do the duty. You know? Mandamus. So writ of mandamus will come to picture. So FIRs, cognizable offences, FIR in certain cases requires pre-verification. FIRs can be filed by any person who is head constable and above. So FIR, if not filed, approach the superintendent of police. FIR not filed, still approach the judicial magistrate. If all of them are neglecting the duties, then approach for a writ in the High Court. Very clear? This is the process. Now comes the concept of zero FIR. So zero FIR is an FIR that can be registered by any police station. By any police station, irrespective of jurisdiction, when it receives a complaint regarding a cognizable offense. So this means, see, theft is also a cognizable offense. So that means, so police cannot deny, yes, it has to file an FIR. So theft also comes under cognizable offense. Or maybe a robbery definitely comes in a cognizable offense. So the police person cannot deny. So here it's clearly written, zero FIR is an FIR that can be registered by any police station irrespective of jurisdiction when it is pertaining to a cognizable offense. Now, no regular FIR number is assigned at this stage. Yes, it's an FIR, but it's termed as a zero FIR. So no FIR number. So there's no serial number for this. The serial number is not there. It's just being termed as a zero FIR. Now, once it is being registered, Now it is transferred to the actual police station in whose area the offense has been committed. So it is transferred to the relevant police station where the offense has taken place or where the investigation is required. Now that police station will now be filing a fresh FIR with proper serial number. That means zero FIR is an information received by the police anywhere which can be transferred to the required police station for now taking actions by lodging a fresh FIR with serial number. Very clear? Now further, it is meant to help the victims of serious crimes, especially women. Initially it started, but it's extended to all the cognizable offenses, especially women and children. Now, it is also meant to ensure that evidence and witnesses are not lost or tempered due to delays in filing FIRs. And the concept was introduced on the recommendation of Justice Verma Committee. So note this is important. Justice Verma Committee after the December 12 rape case in Delhi. Yes, December 12 rape case in Delhi. Justice Verma Committee. So zero FIR. Now, let's also talk a little about general diary. Now, the only difference is I was talking about cognizable offense means FIR. General diary can be non-cognizable and other information. So general diary is a record of all activities and incidents that take place in the police station on daily basis. So section 44 of the Police Act empowers the state government to prescribe the form of general diary. So there's no need of remembering these sections, but here who is empowered to design the format of FIR? The state government. The state government. We know police is a state subject. Okay, so state government is supposed to prescribe the form of the general diary. Now, general diary can be containing the following information: arrival and departure of police officers, okay, arrest of the person, okay, so they cannot hide the arrest, they have to enter in the diary, okay, that they have arrested a person, that should be there in the general diary, that should be mentioned. Seizure of the property mentioned. Receipts and disposal of complaints, how many complaints received and how many complaints resolved, and any other information that an officer in charge may consider necessary to record. Now, there's one more ruling by Supreme Court, CBI versus Tapan Singh. The Supreme Court ruled that a general diary entry may be treated as FIR. Please note, pay attention. A general diary entry may be treated as FIR in appropriate cases when it discloses the commission of a cognizable offense. Now, through general entry, if it is found that a particular case is actually pertaining to the cognizable offense, can be then transferred as an FIR into an FIR register. Very clear? Now, there's one more thing that's called case diary, which is carried by the officer of the police station. Is maintained by the investigating officer for a specific case. Under investigation, while a general diary records all legal events within the police station jurisdiction. So that is general, means every possible information, and case diary means specific investigation with respect to a particular case. So case diary. So all these terms are very clear. Now, let's talk about police arrest here. So in what conditions police can arrest? So we know, first of all, if an FIR has been filed for a cognizable offense, then definitely police can arrest. Okay, the FIR has been filed for a cognizable offense, so police can arrest. Now, in case of non-cognizable offense, if the warrant has been issued by the court, then police is supposed to arrest. So the warrant for arrest by court in non-cognizable offense, the police is now bound to arrest. Now, in case of occurrence of the crime, no FIR has been filed. Now the crime has been reported. There's no time to file an FIR. So police approaching, visiting the crime scene can arrest the person directly. Okay. After filing of FIR in cognizable case, police can arrest. After issue of warrant in non-cognizable case, the police can arrest. And if the crime has been occurred and the information reaching to the police through maybe by a person or maybe by maybe electronic media or maybe a video, police approaches, finally reaches the crime scene and arrests the person if that is there. So here the police can arrest the person. Okay. So these are the areas. Now, one more thing is preventive arrest. Now, preventive arrest is preventing the person who is under suspicion that if that person is let loose or remaining free in the society may commit a crime. So police is empowered to arrest a person when it is satisfied that doing so is essential in order to prevent occurrence of a cognizable offense. So the person is under suspicion that if that person is free in the society may lead to a committing of an cognizable offense, then the police can arrest as a preventive arrest. Police can also make preventive arrest under special laws such as NSA. Now, police officer knowing of the design to commit any cognizable offense may arrest without orders from a magistrate and without the warrant. Okay, the persons who are designing. So that is, police can arrest. Police has the power of preventive arrest. Now, responsibilities of the police. The police officers empowered to investigate a case and file a charge sheet are also empowered to make arrest. Wherever the police intends to arrest a person, it is obligatory for them. So once the police have arrested, so that means the person who is arrested should be knowing certain things. First of all, the police should clearly inform him about the alleged offense for which the police has arrested him. The police should clearly inform. Now, if the person has been taken into custody, that is taken to the police thana or wherever the space is available for the person to be incarcerated or put in the jail or the lockup, that means family or person or the friend should also be informed. So immediately inform a friend or relative about the arrest and the place of his custody. Now for a bailable offense. Now, what is a bailable offense? So bailable offense is that which is a minor issue. So minor issue can be a small theft which may bailable offense are those, first of all, which can attract prison terms of less than 3 years. These are bailable. Maybe an accident. Okay, you have committed maybe a small theft which may not be a very big thing, which may not be a crime which can be considered for 3 years of imprisonment. So those type of things in which the things are bailable or the offenses are bailable, the police should be informing. Yes, the bail can be given by the police station itself. Yes, Harsh.
सर ये जो पुलिस अरेस्ट में था जो ऊपर वाले पेज में था कि पुलिस ब्रेक यानी जो पर्सन ब्रेकिंग द लॉ ये भी कॉग्निजेबल ऑफेंस के अंडर है.
Pardon?
पर्सन ब्रेकिंग द लॉ
हाँ.
वो भी कॉग्निजेबल के अंडर ही ले लिया. अब वो किस तरह का लॉ होगा, कौन सा लॉ हो सकता है?
कौन सा लॉ? कोई भी हो सकता है. ओके, देयर आर व्हाट द पॉस्को लॉ. पॉस्को एक्ट आपको पता ही है.
छोटे मोटे लॉज भी आ सकते हैं क्या?
नहीं. The thing which is ultimately cognizable, which are at least attracting 3 years and more than 3 years of prison.
Then sir, thank you.
Okay, so those are considering the serious crimes. Now, the bailable offenses are those where the bail can be given by the police station itself.
Sir, in
these
case
are
of
minor
house,
pardon?
sir, I have a question. Sir, in case of house arrest, like when a police do house arrest, so is there any warrant required in that case or not?
See, house arrest is not in the hand of the police. It
Okay, sir.
has to come from the judiciary.
Okay, sir.
Okay, it has to come from judiciary.
Okay, sir.
Okay, so minor issues which may attract less than 3 years of imprisonment, these are the bailable offenses in which the police is empowered to provide the bail itself. Okay, so that means if the police, first of all, 3 conditions. If the police is arresting a person, first of all, tell why the person is getting arrested. Second, inform the relative or the friend, okay, that the person has been arrested, and the location where the person has been kept should be informed. And in case if the arrest is for a minor offense which can attract less than 3 years of imprisonment is bailable, then the person should also be told that you can get a bail from the police station itself. Okay, so these are, so now response to the police. Hence comes into picture 2 things, a police custody and judicial custody. So there's a question on police custody and judicial custody. Now let's see. So whenever the person is arrested by police or investigating agency and detained in custody, and if the investigation cannot be completed within 24 hours, the person is supposed to be produced before a magistrate. कहते हैं 24 घंटे के अंदर magistrate के सामने पेश करो. So here simple thing is, if the police on its own is not able to complete investigation within 24 hours, is supposed to produce the person in front of the magistrate. Now, the CRPC and subsequent provisions lay down the procedures that may follow in various scenarios. So first of all, there is a condition of within 24 hours, the person should be put in front of a magistrate for further action. Now the magistrate will be deciding whether the person should be given police custody, that is police lockup, or maybe judicial custody, that is central jail, also known as district jail. Now the magistrate will be deciding. So now the role of the magistrate now. The police custody is subject to judicial review and monitoring. So within 24 hours of arrest, the police must bring the accused person before a magistrate and report on the progress of the investigation. So now what are the actions taken by the magistrate? The magistrate may further remand the person to the custody of police for a period of not more than 15 days. पुलिस कहती है ना कि हमको पुलिस कस्टडी दे दो, ओके, मजिस्ट्रेट और बाकी जो सपोर्टिंग लॉयर्स होंगे फॉर डिफेंडेंट होंगे वो बोलेंगे नहीं सर जुडिशियल कस्टडी दे दो. Because the police custody, in the police lockup, there are more chances of harassment by the police. In judicial custody, there will be investigation by the police with the permission of jail officials. So that is more safe. That is more safe. So hence, the magistrate may further remand the person to the custody of police for a period not more than 15 days. Now, after lapse of 15 days or the police custody, granted by the magistrate, the person may further be remanded to judicial custody. So either initially the police can be given police custody for 3 days, 4 days, 5 days, maximum 15 days, or directly the magistrate can give judicial custody, or police custody initially, then transfer to judicial custody. So if the magistrate is dissatisfied with the police custody, he or she may grant bail or transfer the offender to the judicial custody. So magistrate is a deciding authority. So that's why the person who has been arrested has to be produced before the magistrate within 24 hours. One more thing, police custody also does not imply that police can question the accused without his or her consent here. There has to be consent taken. And the accused has the right to remain silent and refuse to answer any questions. So that's why many people who may be knowing the law say that confession at a police station will not stand in the court. If you confess in the police station, that is not be standing in the court, that's not been seen as the statement by the accused, may be given by the accused on the harassment or by the harassment of the police. Yes. So that's the way the court interprets. Now, judicial custody. The judicial custody means the person is detained under the purview of the judicial magistrate. Is now lodged in a central jail. So central jail, okay, it's not the central government jail. Okay, central jail is the name of a district jail. Okay. Okay, so केंद्रीय कारागृह, okay, or the जिला what jail, okay, वो movies में देखा होगा आपने, बहुत सारे hero villain निकलते हैं उसमें से, okay, ठीक है, so that is called the central jail or the district jail. So in judicial custody, the person can apply for a bail as per the CRPC pertaining to bails and bonds. Now in judicial custody, the maximum time period is 90 days. So a person can remain in the judicial custody for 90 days maximum. But in case of the cases like UAPA, in cases like narcotics case, okay, for that duration is 180 days. 180 days, which can also be extended further. But here, in all the other type of cognizable offenses, maximum judicial custody is 90 days. Now, in police custody, the investigating authority can interrogate a person. Yes, the police will be given a chance to interrogate the person in the jail itself, but on the basis of permission of the court. The police cannot be forcing the person to answer. Yes, first of all, police will take in the permission of the court, then go to the jail, then meet the person, then start interrogating. Friends, that's why the judicial custody is seen as a safer option in comparison to police custody. Yes, also in the police custody, the person has the right to consult a lawyer. An under trial person cannot remain in judicial custody beyond the half period of the prescribed maximum punishment. Now, under trial person who is an accused, yes, who has now been in jail, case is going on, and if that person, in extreme cases, there are cases where the people are not yet released after 90 days of judicial custody, still in jail. So the maximum limit is they cannot be in jail for more than half the period if they would have been convicted. If they would have been convicted, so they should be released. So what type of people can be released? who may not attract life imprisonment or capital punishment. Such type of people can be released. Now, so when you talk about custody, so there always comes a question of bail. Yes. So we are talking about different types of bails now. So bail is a conditional provisional release of a person held under legal custody by undertaking a promise to appear in the court as and when required. Yes. So that means the bail is given on the basis of a bond, okay, or the surety money, that whenever you are being called by the police, whenever you are being called by the court, you should be coming. Yes. Now that is the conditional provisional release. So hence, this brings you to picture which are the bailable offences and which are the non-bailable offences. Yes, Harsh.
सर जुडिशियल कस्टडी और लीगल कस्टडी में क्या फर्क है?
वही है, same.
थैंक यू.
So is there a difference between FIR and a charge sheet?
Yes. FIR is the first information report. That means the police have received the information to investigate a crime. Very clear. Now,
Yes,
when the
sir.
crime investigation has been completed by the police, that means the police is now put a charge sheet to be against the accused, and that charge sheet should be produced in the court for then filing the court case.
Okay, sir. So
Anna?
one more thing.
I hope it's very clear. FIR, for
Yes, sir.
example, I am a witness of a crime or I am the victim of a crime. I am approaching the police, okay, and that is a cognizable offense. So I am getting the FIR registered. I am giving the first information. Now the police will start an investigation, investigate the entire matter, then create charges. Charges under what? IPC sections, CRPC sections. Then charge sheet is being created. Now what are the charges against that accused? And that charge sheet is now presented in the court for further action by the court.
One more thing, sir, like the police custody does not imply that police can question the accused without his or her assent. Right.
That is as per the law, yes, but that is
Right.
usually not the case.
Right, exactly. That's what I'm asking. So who ensures that? Like maybe with the consent, maybe without the consent.
So actually consent form is being got signature by the police, yes, but we know the police can use pressure to force the person to sign also.
Right. Also, in case of judicial custody, like after court has given the permission, like okay, you can investigate whatever the whoever is in the prison. So after that, they can do that sort of violence or something. They have the right.
No. So that is under the scrutiny of the jail officials.
Okay.
Okay, so that is scrutiny of the jail officials. So that means the police has to take permission from the court and will be the police will also be under surveillance, yes, within the jail.
Okay.
Okay.
Sir, I have a question. Like in case of both judicial and police custody, can the duration be increased, like after the certain duration which is mentioned in the laws, which is like 15 days?
And again, it depends on the court. For example, if the court has given a maximum duration of 15 days of police custody.
Yes, sir.
Then police can again approach the court ki our investigation not yet complete. We want what 15 days more or 1 week more. Then police can ultimately demand. And now it depends upon the judge whether to give or not.
Okay, sir.
Okay.
So, we have read that in judicial custody, like in jail, a person cannot be there for more than half the time period of the punishment. So then
Under trials.
Under trial. So then why we read that there is overburdening of jails and there are so many under trials in the
Okay, so now the matter is moving towards now the conceptual part, which is not current affairs, but I will be giving the reason here. Now we know we have got overcrowded prison systems, and more than 70% of under trials are mostly for what small offenses, okay, or small crimes. Now we know our judiciary is highly overburdened, and there are lesser number of judges in our judicial system. So what usually happen is many of the cases are not heard for a longer duration of time, or they may be heard very occasionally. And finally, what happens, the people have to, who are under trials, they have to serve enormous years in prison. So there was a general, even in section 436A CRPC, there's a provision that under trials should be released if the cases are not being heard regularly for them, if they serve half the prison term, if they would have been convicted. Okay. So that's the condition they have put. But now,
Okay, sir.
but for releasing them, there should be a manner of releasing. And for that, our jail system should be very, very perfect. They should be knowing, they should be profiling the behavior of the prisons. They should be putting their efforts in building their capacities. They should be remodeling them so that they can return safely to the society. But for that, our jail system is not equipped enough.
Yes, sir. Yes.
So there were practical issues, but when you talk about the law, when you talk about the statements, these are the statements which are there in the books. That is the law books.
Okay, sir.
Okay.
Okay.
Okay, so when you talk about bail, so bail can be conditional release with the condition that if the person is being called by the police or the judiciary, should be producing himself or herself when asked. Now, when you talk about bails, can be of two types. One is called bailable offense and can be non-bailable. So bailable offense are for lesser serious issues, are considered less serious, and the punishment is less serious, and the accused has a legal right to request release on bail. Hence, this applied for those cases where the punishment is less than 3 years. And who is empowered to issue the bail? The police itself. So when the police is able to issue the bail, that is called bailable offense. Non-bailable offense means of when the punishment is more than 3 years. Non-bailable does not mean that bail will not be given. Non-bailable means the police cannot give bail, but the court can give bail. So non-bailable offenses means who is empowered here? The court is empowered. Court is empowered for giving bail, not the police. So police is not empowered here. That's why this is termed as non-bailable. Simply put it means the accused is not permitted to demand it as a matter of right at the time of their arrest by the police. However, they are permitted to approach the court while they are being prosecuted. So court can give, yes, bail in the cases of non-bailable offenses. So non-bailable crimes are for those which are 3 years and more. Okay? This is the general terms or general statements which you should be knowing. Now, we talk about bails now. So what type of bails? One is termed as a regular bail. Now, regular means the person has been let off by the court for a longer duration. That is a regular bail. But a case is still going on. Yes, but a person is released, is not under custody. Okay? So it is a direction given by the court to release a person who is already under arrest and kept in police custody. So if the police is not able to investigate properly, has harassed the person, and now the magistrate has seen that, okay, even there's no requirement putting the person in the central jail, let a person be released. Yes, but a case is still going on, investigation will go on, but without the person being put under custody. That's called regular bail. Now there's an interim bail. The interim bail is for temporary period, till the time the regular bail application is being finalized by the court. Okay, so for example, if I am being arrested, okay, I can find, okay, give me interim bail at least. Yes, I have to do certain work, important work, and I also filed a regular application of regular bail. Till the time the regular bail is being considered, court can give me interim bail for 3, 4, 5, or 6 days. Okay, so it's called interim bail. So interim bail is provided as a temporary measure and is valid only while an application is ongoing, when the court is considering for anticipatory or regular bail. So regular bail is person is released from the custody. Okay, case may be going on, but the person is not in prison. Interim bail comes into picture when the application for regular bail is already being filed. In the meanwhile, maybe a permission in the form of interim bail can give the person a release for few days. Okay. Now, if the regular bail is not approved, then the person can be rearrested. So, yes, Sai.
Sir, in the case of bailable offences, is it a discretionary power of the police to give bail?
No, see, for example, there is what proper classification of the offences, yes, in the police rules and regulations. And then the police rules and regulations, so which are the crimes or offences which are less than 3 years and above 3 years. If the person who is been arrested are falling within 3 years category, has to be told, it's necessary. Yes, many times the police personnel may be acting in a manner where they may not be helping the person who is accused to get bail. Yes, But that is a thing which is a managerial thing or administrative things, which requires various internal reforms. Okay, attitudinal change is also required. But here we are talking about the what is actually expected. I hope
Lecture. Thank you, sir.
So interim bail. Now, accused loses his right to be free and will be taken into custody if the interim bail expires before the giving of regular bail, or the regular bail is denied. Then after the interim bail is over, person can be arrested. So interim bail is always conditional and can be prolonged also. Now, what is anticipatory bail? If I am anticipating that I can be arrested and I'm an influential person, this usually happens with the influential person, because they can put out expensive lawyers, they can hire big lawyers, and if they are feeling that they are going to be arrested, so they can, with the powerful lawyers, and by putting what reasonable arguments, can get what anticipatory bail, anticipating an arrest, hence anticipatory bail, so the police cannot arrest now. So anticipatory bail is self-defining. It is a type of bail that is given to someone who is in anticipation of getting arrested for a non-bailable offense. So this is an advanced bail. An application for anticipatory bail can be heard both by the Court of Sessions and the High Courts. So what is Sessions Courts? Sessions Courts is the highest criminal court. We are discussing what subordinate judiciary a little later. Highest criminal courts at district level. Highest criminal court at district level is known as Court of Sessions. And yes, we know High Court is above the district courts. Yes. District court. So anticipatory bail can be given only by the district and higher courts, not a lower court. So this is again a statement for you. Yes, can be given by only the court which is at least of district level. Now further, can the police call someone for investigation even if granted anticipatory bail? If the court has given somebody anticipatory bail, can still the police question the person? Yes, the court only forbids the arrest. In the case of anticipatory arrest or anticipatory bail, only the arrest has been set aside, but a person can be questioned by the police. The court only forbids the arrest, but does not prevent police calling the accused for investigation. That person can be called to the police station also for investigation. In fact, this is a condition of anticipatory bail that the accused shall make himself available for investigation as and when required by the investigating officer. Refusal to do so may entitle the investigating officer to move the court for cancellation of the anticipatory bail. Anticipatory bail. Now, let's talk about a condition. Anticipatory bail means you are anticipating an arrest, you are getting anticipatory bail from the court, but you should be making yourself available for the police or an investigating officer anytime when it is demanded. In case you are not abiding by the investigating officers' requirements or orders, there are chances that your bail can be cancelled by the police filing an application for cancelling the bail. Another thing is, in case the investigating officer finds that a criminal case is actually made out against you, you are actually not the accused or the culprit. Okay, then finally, investigating officer has the power. Yes. Okay, has the power. What power? Again, let's read the statement. In case the investigating officer finds that a criminal case is made out against an accused, granted anticipatory bail by the court, he will not arrest. Yes, investigating officer will not arrest the person, but will release him on bail, even if the offense is non-bailable. Non-bailable. That means in case of anticipatory bail, investigation is being done by the investigating officer. Now that officer finds that the case does not stand, and actually you are not the the accused. Yes, you have been falsely implicated. If the officer finds, then officers can ultimately file for the bail himself and get you released. Yes, get you released, even if the offense is non-bailable. So different type of bails, and one bail is called default bail. So default bail is very simple. If the investigation is not completed by the police for the time duration given to the police is not able to file the charge sheet, then by default, the person will be released. So this is a right to bail that accrues that police fail to complete investigation within a specified period in respect to the person in judicial custody. So it is also known as statutory bail. So how many bails we have seen? Yeah. Regular bail, interim bail, anticipatory bail, and default bail. So default means by default because the investigation is not completed within stipulated time. Police is
Sir,
not
I have
able to
one
file the
question.
proper charge sheet against you. Yes.
So I have one question.
Yes, I. Anant, yes.
Sir, in case of interim bail, is there any provision that a person can apply for the extension of the duration of the bail till the time the regular bail is not approved?
For example, there have been various cases. Yes, for example, the interim bail, first of all, there's no fixed duration. It entirely depends on the court whether to give or not. Or court can also say that that we are not giving you interim bail. Yes, your regular bail is under consideration. We'll be deciding on the basis of regular bail. It entirely depends upon the court.
Okay, sir.
Okay. I hope all these bails are very clear. Now, so what Tanya was asking, this is the condition. In case of under trial, as per section 436A of CRPC, if the accused is under trial and has under judicial custody, undergone half of the maximum prison terms, then such person can be released, yes, if the case hearing is not regular. Right? Case hearing is not regular, such person can be released. But this does not apply to whom? On default bail, but not being an offense for which the punishment of death has been specified as one of the punishment under law. If the person can attract a death punishment or death penalty, those people will not be released in such cases. But under trials who have served, for example, if the person would have attracted 7 years of prison, if the under trial already served 4 or 5 years in prison, that person is eligible for early release. Early release, that is the condition in the CRPC 436A. But again, processing is very difficult. But there's a provision is there. And it does not apply for the people who may attract capital punishment. So 436A. So this also comes under default bail. Release of under trials is also coming under default bail. Again, remember, release of under trials on the condition of serving more than half the prison term is also coming under default bail. All the students, all the terms are clear till now? Okay,
So,
now this is
Yes, sir.
second last condition, if you could come again, the capital.
Second last condition, Partha Sathi. Which one? Which one?
The one which involved with capital punishment, sir. The default.
Capital punishment. Okay, this one under trial and capital punishment.
Yes, sir. Yeah.
Okay, so we all know that there are different levels of punishments. 3 years, 5 years, 7 years, 10 years, life in imprisonment, which can be of initially 14 years, which can be extended, or there can be capital punishment means that means that is to be hanged. Yes, that is capital punishment is to be hanged till death. So in case of those cases, under trials, first of all, under 436A CRPC, all the under trials for whom the investigation and hearing is going on is under judicial custody, that is in prison. All the persons are eligible for early release if they have completed more than half the prison term, if they would have been convicted. But which under trials cannot be released? The which are under heinous crimes for which the category of capital punishment also apply. So heinous crimes means rarest of rare cases, which the Supreme Court has defined. For example, extreme brutal rape cases. In those cases, that person will not be released. Very clear?
Got that, sir. Yeah.
Okay, thank you.
Is there a difference between jail and prison in terms of the
So
custody?
there are two things. One is a lockup, one is a jail. Yes. One is lockup, one is jail. So lockup is in the police station.
Police station, right?
Na? Jail is actually when the person goes under judicial custody. That is jail. Okay.
And prison is post conviction.
So उस जेल को क्या बोलते हैं? हमने बोला कभी हम सेंट्रल जेल भी बोलते हैं, कभी हम डिस्ट्रिक्ट जेल भी बोलते हैं. We call district jail or central jail. Clear, Partha?
Yes, sir. Yes, sir. Yes, sir.
Okay. Okay. Now handcuffing, हथकड़ी पहनाना. So Whether it is mandatory or not, still there are certain conditions. Handcuffing. So there can be 3 different occasions when the person can be legally handcuffed. Again, first is an accused on his arrest. That means when the police is arresting the person can be handcuffed. And before he is produced before the magistrate, while taking to the magistrate, that person can also be handcuffed. So the person does not run away. Okay? So while arresting the person can be handcuffed. While arresting the person. That does not mean that a person while taking the police jeep or the police van should be handcuffed till the police station. There's no requirement. Arresting, you put in handcuff and you can remove the handcuffs while in the vehicle. This can be done. So here an accused on his arrest and before he is produced before the magistrate. Now an under trial prisoner during transit means during travel time. For example, from the jail, it is now taken to the court. That means there is a chance that a person can escape. For that time, that person can be handcuffed. A convict being transported from jail to the court and back. So these are the conditions during the transit, okay, during the arrest, okay, when presenting in front of the court, but not in the court. Yes, not in the court. The person should not be put handcuffed and in front of a judge. Yes. So these are the conditions for handcuffing. And for handcuffing, the arresting officer must record the reasons in the police diary. So these are general things which even the lay person should also be knowing with respect to the police and police actions, because this can happen with any one of us. Okay, maybe we have done anything wrong or not, it does not matter, because police have got extreme power, so we should be knowing how to defend ourselves. So these are the things. That's why UPSC is more focusing on what? General awareness based examination. Theory everyone is reading, but what is actually focusing on is awareness, which can be different from just mugging up the theory. Now, let's talk about subordinate courts, not court, courts. So I was talking about it. I will not be discussing about the Supreme Court. I will not be discussing about the High Court, because those courts you read in your basic polity books. But usually the courts which you are not reading or neglected in your studies are the subordinate courts. So that's why judicial magistrate, chief judicial magistrate, or chief metropolitan magistrates, there are different type of magistrates. So you should be knowing. So state judiciary consists of a high court and a hierarchy of subordinate courts, also known as lower courts. So when we talk about a state judiciary, topmost is the high court, below comes the subordinate courts. Now the organizational structure, the jurisdiction, and the name of the subordinate judiciary, that is nomenclature, are laid down by the states. So subordinate judiciary names can be different in different states. So this is a point to note. So this is a point to be noted. The structure, the range of jurisdiction, that is the number of cases or the range of cases it can hear, and the names of the subordinate judiciary are to be decided by the states. Hence, they may differ from state to state. Now, the topmost at the subordinate level are at the district level. So hence comes the district and session court. District and session court. Now, district and session court, the topmost court in the district. Now, the district judge is the highest judicial authority in the district. District judge. Now, that district judge, while acting as a civil judge, is termed as district judge. The same district judge, while acting as a criminal judge, is termed as a session judge. So let's see. He possesses original and appellate jurisdiction, means original as well as appeal from the lower courts in both civil and criminal matters. So when that district judge deals with civil cases, this is important. So he is known as a district judge. And when the same person hears the criminal cases, that person is known as sessions judge. I hope very clear. Okay. Now, when we talk about a district judge have got two nomenclatures. Just a district judge when hearing the civil cases, then a session judge while hearing the criminal cases. So district judge exercises both judicial powers and administrative powers. Judicial and administrative powers. So judicial powers with respect to the cases that are being heard by the judge, that is both the civil and criminal matters, that's called judicial powers. And administrative powers means administration of the court. Okay, that is which case to be assigned to which bench. Yes? So that is called administration of the court. So he also has the supervisory powers over the subordinate courts in a district. That means at the taluka level, or maybe even at the panchayat level of their courts, so that is called supervisory power. So this is called district and session court. So now, appeals against the orders of a district judge and the judgments lie to the High Court. The session judge has the power to impose any sentence, including life imprisonment and capital punishment. Now remember, that means the session court, that is a district judge acting as a criminal judge, yes, okay, or that hearing the criminal matters as a session judge, can ultimately give life imprisonment also, as well as what? Capital punishment also. That means that district judge has got enormous power to even give what? Death sentence. So court of the subordinate judges. Now, so that means at a district level comes what? Your district court, and which is also termed as sessions court. Now, below the district levels come your court of subordinate judges. Again, they can be divided into two, civil and criminal. Friends, below the district and sessions court stand the court of subordinate judge for civil side, and for the criminal side, this person is now known as Chief Judicial Magistrate, CJM. This again you must have heard in various cases, even the movies, CJM ki Adalat, Post Chief Judicial Magistrate. So CJM is below the district level. Below the district level, CJM is for criminal cases. Court of subordinate judge for civil side, as well as for now CJM, the subordinate judge, that is civil judge, can impose unlimited pecuniary jurisdiction of civil suits. Can issue the orders for unlimited fines. That means the subordinate judge for the civil side or the civil matters can have the power to issue the fines of unlimited extent. That means that power is very wide. Now, when we talk about a CJM, which is looking into criminal matters, can provide imprisonment for a period up to 7 years. Up to 7 years. Now, the district judge who is acting as a sessions judge can even give capital punishment. But a chief judicial magistrate below the district can give up to 7 years. Now, for example, 7 years means attempt to murder, culpable homicide, there is attempt to murder, robbery, voluntary creating hurt, or maybe hurting someone, cheating, or maybe harassing a woman, yes, or death caused by negligence. All these can attract up to 7 years. So here the CJM is empowered to give punishment up to 7 years. Very clear? District, now subordinate, CJM. Now let us move below that also. At the lowest level of the civil side is the court of Munsif court. So the lowest civil court is the Munsif court. Now the Munsif court can issue smaller fines, small pecuniary stake, small fines. And on the civil side is a JM, judicial magistrate. And that judicial magistrate can give punishment up to 3 years. 3 years. So district judge up to capital punishment and unlimited fines in case of civil matters. When we talk about subordinate, civil court again can give what? Unlimited fines, orders, but the CJM can give punishment up to 7 years. Lower level of court, the lowest civil court, Munsif court, that means smaller fines, and the lowest criminal judge, that is judicial magistrate, can give punishment up to 3 years. For example, eve-teasing, seeking sexual favors, or maybe video recording, yes, okay, on harassing the people, theft and pickpocketing. Now, one more thing for the metropolitan areas, that means the bigger cities, metro cities. There can also be metropolitan courts. In some metropolitan cities, there are also city civil courts headed by chief judges, and the courts of metropolitan magistrate means CJM, court of metropolitan magistrate, sorry, on the criminal side. So these are for the metro cities. Now, we know that the lower judiciary, the power is there with the states to create more courts anywhere. Even at a town level, the state governments can create more courts. And these town level courts are termed as small causes courts. We will create a hierarchy, do not worry. Yes. Now, so let's do one thing. You may be a little confused. Let's remove the confusion. So let's start with very simple thing. Let's start at district level. So district level, when you talk about the district judge, while acting as a civil judge, is termed as district judge. While acting as a person hearing the criminal cases, is termed as a session judge. Below the district comes what? Subordinate civil judge and chief judicial magistrate, CJM. Below these come municipal courts, civil, and here judicial magistrate. That is 3 layers. Now, the additional can be for the metro cities, there can be chief judges for civil matters and metropolitan magistrate, MM, for criminal matters. These are for the metro cities. Now, state government has also got the power to create smaller level courts for the town level also. Hence, some of the states and the presidency towns. We know the presidency towns earlier were when we talk about the British presidency towns. They are also established small causes courts. These courts decide the civil cases small value and their decisions are final, but the High Court possesses the power of revision. Even there are cases where the panchayat courts can also be created. So in some states, panchayat courts try petty civil and criminal cases. And they are also known as Nyay Panchayats, Gram Kachari, Adalati Panchayats, Panchayat Adalat. That means the names may differ across the states. So these are basically the subordinate courts starting from the district till the panchayat level. Very clear? Any doubt in any student? Yes, they can ask.
हेलो नमस्ते सर
हाँ
सर
नमस्ते.
मुझे पूछना था कि जुडिशियल इंक्वायरी और मैजिस्ट्रियल इंक्वायरी में क्या फर्क होता है
हाँ, जुडिशियल इंक्वायरी और
मैजिस्ट्रियल इंक्वायरी
सेम, क्योंकि मैजिस्ट्रेट से आ रही है तो जुडिशियल इंक्वायरी हो गई ना वो.
सर न्यूज़पेपर में ना 2 अलग अलग लिखा था कि इनकी जुडिशियल इंक्वायरी भी होगी
हाँ.
मैजिस्ट्रियल भी होगी तो जुडिशियल में तो जुडिशरी का समझ आता
नहीं, उसमें क्या है कि अगर उसको हायर लेवल पे लेके जाएंगे, है ना, मैजिस्ट्रेट और टू टिल व्हाट लेवल, मैजिस्ट्रेट और मैक्सिमम टिल व्हाट सब डिस्ट्रिक्ट लेवल.
ओके सर
है ना, अगर उससे ऊपर लेंगे तो फिर टर्म फुल को इसको जुडिशियली बोलेंगे, उसको मैजिस्ट्रेट नहीं बोलेंगे.
ठीक है
तो अगर तो ये मेजर डिफरेंस है. मैजिस्ट्रेट इज अप टू अ सर्टेन लेवल बट अबव दैट इज ओनली जुडिशियल.
मुझे लगा वो एग्जीक्यूटिव अथॉरिटी होती है तो वो डिस्ट्रिक्ट कलेक्टर के पास में होता है
नहीं, वो कुछ केसेस में होती है डिस्ट्रिक्ट कलेक्टर के पास. फॉर एग्जांपल लैंड रिकॉर्ड्स का हो सकता है उसके पास, डीएम के पास.
ओके
The for that DM can also be the acting as a magistrate in certain cases like land record and revenue issues, है ना.
राइट ठीक
वहाँ पे DM as a magistrate काम करेगा.
ठीक है
Okay, yes, Anant Gupta is asking what is verism. For example, verism means, for example, any mischievous person is recording some intimate what scenes of a couple, yes, in a video, in a recording video. That's called verism. So the intention may be just for your own pleasure or for harassing the couple, putting that in YouTube, yes. So it can be used in different manner, yes. So that is called verism. I hope it's clear, Anand. Okay. Now, and an institution which is in news is ED. Now let's talk about ED. Yes, so Directorate of Enforcement. So some basic things about ED. It has been news regularly. Today the ED got maybe a sound beating from the Supreme Court, yes, and finally a person from Aam Aadmi Party, Sanjay Singh, was released, yes. So let's talk about ED also. So now, so Directorate of Enforcement. So ED has got a beginning after independence. Okay, how it emerged, a little background, and how it functions. Yes, what are the areas of intervention? Let's talk about of ED. So ED, or Director of Enforcement, is a multidisciplinary organization mandated to be investigation of the offenses linked with money laundering and violation of foreign exchange laws. Okay, that is FARA and also what money laundering. So that means these two type of cases come within the mandate of ED. Now it functions under Department of Revenue. Where? Department of Revenue, because here it is linked with money, money and money. So where it should be ideally be placed? Department of Revenue, Ministry of Finance. So again, important point. And it is a premier financial investigation agency of the Government of India. Now let's see the genesis, how the ED actually started. The origin goes back to 1956, when the enforcement unit was formed, not under Department of Revenue at a time, but Department of Economic Affairs. Yes. Again, this is a point to be noted, that it has got an origin not under Department of Revenue, but in Department of Economic Affairs in 1956 for handling exchange control laws violation under FARA of that time, Foreign Exchange Regulation Act 1947, headed by a legal service officer. We know headquarter was New Delhi and the other two branches, Bombay at that time and Calcutta at that time. Yes. Now Mumbai and Kolkata. Now further, in the year 1957, this unit was renamed as Enforcement Directorate. So the name as Enforcement Unit was now replaced with Enforcement Directorate. And one more branch was added, that is Chennai, that is Madras. Now further, now in 1960, yes, the administrative control of the ED was transferred from Economic Affairs to Department of Revenue. So it has got a beginning in 1956 under Department of Economic Affairs. Now in 1960, it got shifted to Department of Revenue Control. And with the passage of time, the FARA 1947 was replaced by FARA 1973. But now with the coming of what the liberalization era. Now liberalization, because FARA was a regulating act. Now we have opened our economy. So instead of regulation, we require management of foreign exchange. So hence the FARA was replaced by FEMA. Yes. Now further, in tune with international anti-money laundering regime, then a new law came in 2002, that is PMLA, Prevention of Money Laundering Act. And ED was entrusted with its enforcement with effect from 2005. So that means what we came to know, ED had got a beginning in what? Department of Economic Affairs in 1956. Later, it was shifted to Department of Revenue in 1960. Earlier, it was for the issues with what violation of FARA. Finally came FEMA after liberalization. And finally also came also what? PMLA 2002. Now, what is the structure of ED now? Now, ED headquarters of Delhi is headed by Director of Enforcement. Yes, the ED Director, we call it simply ED Director. And there are 5 regional offices. So now, earlier there were only 3 offices, Bombay, Madras and Calcutta, now 5. So Mumbai, Chennai, Chandigarh, Kolkata, Delhi. Yes, there's one regional office within Delhi also, besides the main headquarters. Now these are headed by special directors of enforcement. So main director, then special directors for the regional offices. Now further 10 zonal. So there's no need of remembering all these things. Now only the director and the 5 major regional things. Now ED was given the statutory status, so it became a statutory body. Remember, so UPSC again asked which of the following is a statutory body, which is the executive body, which is actually a constitutional body. These are the things UPSC asked. So this initially it was not, but it was given a statutory status through Central Vigilance Commission Act 2003. So under which act? CVC Act of 2003. Now further, Now, recruitment of the officers is done directly by ED itself by drawing the officers from various, all India services, investigative agencies. So it can draw service officers from IRS, IPS, IAS, and other income tax exercise. So it depends upon the directorate itself from where to procure their officers. Now, the how to appoint the director of ED. Yes. So let's see the appointment procedure. The ED director is appointed by the central government on the recommendation of a committee. Now that committee comprises of, is chaired by the CVC, Chief Vigilance Commissioner, is the head of the selection committee, CVC, and other members are Vigilance Commissioners, Home Secretary, Government of India, Secretary, Department of Personnel Training, and the Revenue Secretary. So three secretaries, Home Secretary, then DOPT and the Revenue Secretary, and the Vigilance Commissioners, which can be depending upon the requirement. So these are the selection committee for the ED director. Now tenure. Now latest changes in November 2021, the President of India approved two ordinances allowing the center to extend the tenures of the directors of the CBI as well as ED. It was initially 2 years, but after completion of 2 years, it can be extended 1 year at a time till the maximum of 5 years. Okay? That is 2 years up to 5 years. Can now be given 3 annual extensions after the completion of initial 2 years, 3 annual extensions. Now, which are the areas, which are the acts which ultimately come within the investigation of ED? We all know PMLA. ED has been entrusted with the responsibility of executing the provision of PMLA by conducting investigation to trace the assets. Now, whether the ED has also got its court, yes, certain district courts can be designated as PMLA courts. So this is also important. Important note. For the trial of the offences punishable under Money Laundering Act, the central government, in consultation with the Chief Justice of the High Court, that means the central government, in consultation with Chief Justice of the High Court, can designate one or more sessions court. Session courts means district level criminal court. Sessions courts means district level criminal court as special courts. And these can also be called as PMLA court. Okay. It is also called as PMLA court. Now one more act came in 2018, Fugitive Economic Offenders Act. Yes. So we know Vijay Mallya, we know Mehul Choksi, or we know various type Lalit Modi type of people. Yes. Now, so this ultimately also brought within the investigation of ED. So with the increase of the number of cases of economic offenders, see, the Muskan, the actual tenure is 2 years. Now, what the new changes which has become to be, so 1 year at a time, it can be extended from the 3rd year, it can be extended 1 year, 4th, 1 year more, 5th, 1 year more, and that's the end. It cannot be extended further. Okay. Okay, now. So, Fugitive Economic Offenders Act. So, two major acts which are under the investigation of the ED are these two, PMLA and the Fugitive Economic Offenders Act 2018. Now, let's see further. So, attaching of the properties, selling the properties, this is we have heard in various time in news. Now, one more thing we need to add on is CBI, Central Bureau of Investigation. So ED you can easily revise. It started in the Department of Economic Affairs, shifted to Department of Revenue in 1960. Okay, and initially FERA, then FEMA, then PMLA. Now ED director, how they are appointed. Officers can be drawn from different all India services and even below inspector level also. They can be rolled in. Now there's a selection committee. 3 secretaries, 1 vigilance commissioner, and the head of the CVC. All these are the selection committee. And a tenure of 2 years, which can be extended 1 year at a time to the maximum of 5 years. So all these ED and 2 major acts, yes, PMLA and what Fugitive Economic Offenders Act, yes, all these. Now, next comes the picture, CBI. Now CBI, yes, the premier. So CBI has got an origin before independence, not as CBI. The name CBI came in 1960s. So, but it has got an origin before independence. So CBI is the premier investigating police agency in India. So it also provides assistance to CVC in terms of investigation and also to the Lokpal. So it's the topmost investigation police agency in the country. It also provides its support or support of investigation to CVC as well as Lokpal. It functions under DOPT, Department of Personnel, which comes under PMO, Prime Minister's Office. However, for investigation offences under Prevention Corruption Act, that is 1988, it is supervised by CVC directly, Chief Vigilance Commission. So as a premier policing agency, it ultimately assists what? The CVC and the Lokpal. Now, in case of the direct cases of corruption, so supervision is shifted to CVC. Now it is ultimately functioning under DOPT, which is under PMO, Prime Minister's Office. Now, how it originated? It is also a nodal police agency, which also coordinates with Interpol, International Police Organization. So Interpol has got representation from various institutions from respective countries. So which institution represents India? The CBI represents India in Interpol investigations. CBI. Now, it began actually in World War II because there was a huge corruption which was witnessed in World War II in terms of procurement and supply during the war. Now, hence, during the World War II, the Special Police Establishment, SPE, was constituted in 1941 in the Department of War of British India to inquire into the allegations of bribery and corruption in the war-related procurement. That means to look into corruption linked with procurement, linked with World War II. So hence, it was an agency which was created to look into corruption. Hence, later, when the war got over, it was given the complete responsibility investigating corruption in procurement, supply, and other cases. Later on, it was formalized as an agency of Government of India to investigate into allegations of corruption in various wings of Government of India by now enacting Delhi Special Police Establishment Act 1946. So CBI, just note again, is not a statutory body, but derives its power to investigate from Delhi Police Establishment Act 1946. Now, even the establishment of CBI was recommended by, you must have heard about Santhanam Committee, which was constituted by Government of India to look into the corruption in various government departments and ministries. So the establishment of CBI was also recommended by Santhanam Committee on the Prevention of Corruption. That is committee constituted in 1962, submitted report in 1964. Hence, on the initial recommendation of this committee, the CBI was formally created in 1963. The CBI was established by the Government of India with a view to investigate serious crimes, first of all, related to defense, corruption in high places, serious fraud, cheating, crimes, social crimes, hoarding, black market, profiteering. Now, later, the power of CBI to investigate were extended to other high-profile criminal cases like assassinations, kidnappings, hijacking, crimes committed by extremists. So from origination as an agency to look into the corruption cases, but finally now all types of cases. That's why it evolved as the topmost police agency in the country. Now, appointment committee, how the directors are appointed of CBI. The CBI directors appointed according to the provision under Delhi Special Police Establishment Act and amendments brought through Lokpal and Lokayukta Act. That means provisions of both the acts will apply to ultimately what select the directors of CBI. Now it brings 3-member appointment committee, an appointment committee which was also supposed to be constituted for the selection of the election commissioners, which was recommended by the Supreme Court. That is the Prime Minister, the Chief Justice of India, and the leader of the opposition, which was ultimately proposed also for the election commission, but finally it was replaced by the act of the government. So here the similar type of committee ultimately appoints the CBI directors. The appointment committee comprising of the Prime Minister as the chairperson, LOP, Leader of Opposition Lok Sabha, and a CJI, or a Supreme Court judge which is nominated by CJI. Now, are there what separate CBI courts? Yes, there are separate CBI courts also. The CBI courts are established under, again, Delhi Police Special Police Establishment Act as a parallel judicial system, not parallel judicial system, but a supportive judicial system, so as to what process the cases as fast as possible. Because the normal judicial systems, the things are delayed. So a CBI magistrate is appointed, who is the rank of CJM, Chief Judicial Magistrate or Judicial Magistrate. That is a rank lower than district judge. A rank lower than district judge. Now, hence CBI courts are in the form of district courts, but the rank of the magistrate is lower than the district judge, and these courts are made to deal with the cases specially dealt by CBI. So any number of CBI courts can be created depending upon the requirement. So there's no fixed number. There's no fixed number. So a district and session court decision can be challenged, as the district and session court decision can be challenged in High Court. Similarly, CBI court decisions can also be challenged in the High Courts. Similarly, decisions of CBI courts can also be challenged in the High Court. So this is again point to be noted. Now, the strength of the CBI court depends upon the number of cases. So that means the number of CBI courts can be increased or reduced depending upon the cases. Now, judges of the CBI courts are officers of regular cadre of the state judiciary. Now, one more thing to note here is, once these officers are on deputation to CBI courts as judges, for that period of time, they cannot hold regular courts. So they will be solely working as a CBI court judge. So this is also important point. I hope all the things that we have discussed today are very clear. Okay.
Sir, I have a doubt regarding the CBI only.
Boliye.
That, sir, like recently some states have removed the open permissions of the CBI. Like they have to ask for.
Your voice cut rahi hai. Yeah, Anant, your voice is breaking.
Am I audible, sir?
Yes, yes.
Sir, I have to ask that, like some states like have removed the open permissions for the CBI. Like if they want to inquire for any case, like they have to ask for the permissions from the concerned state governments. Like मुझे इसी में थोड़ी confusion होती है कि like are they allowed to like cancel their.
So you are saying that sometimes the state government may not be giving the consent to prosecute. Yeah?
Yes, sir. Yes, sir.
So yes, so it's basically it's also the power of the Supreme the state governments to ultimately give the permission to prosecute or not, but depending upon the type of the case.
Okay, sir.
For example, if there's the case linked with narcotics.
Okay.
Okay, so that is actually a very high punishable offense. So here the state government cannot deny giving permission.
Okay.
Okay, so in that scenario, I hope.
Yes, sir. Like in like when it is related to some like state cases only, like the state governments cancel the permissions and like they
For
don't
example,
allow.
if the cases of corruption are being reported or being accused against the ministers of the state government.
Yes, sir. Yes, sir.
So there the state government may be using its power to deny the permission.
Okay, sir.
Okay, but not in the cases of the narcotics related cases.
Okay, sir. Okay, got it. Got it. Thank you, sir.
Okay. Okay, so so these are the contents. So let's now do some locations. Okay, let's now do some locations. I hope the content part. Yes, let's do some locations now. So I'll be sharing the fresher and what more clear pictures. Just a moment. Okay. So our focus area since yesterday is Middle East. Now, yesterday we have done what various areas of Middle East. Yes, Jordan we completed last. Now we are going to start with Israel. Yes. Now we talk about map of Israel. Now, when we talk about Israel, so again, when you see Israel, yes, it's a long country, yes, almost like a dagger, yes, in the heart, hitting the earth, yes, or going into the earth, yes, it's almost like a dagger. Now, when you see this Israel, what we are finding again, the same type of locations that we discussed with respect to Jordan. For example, again, the Sea of Galilee is visible. Now, so Galilee is also known as Lake Tiberias. So, and the name of Sea of Galilee is Lake Tiberias. Again, this should be known by you. Now, further, when we see the Jordan River, again, it crosses and cuts from north to south, enters the Dead Sea. Now, this we have done again yesterday. Now, let us focus on certain important ports and cities of Israel first. Now, Haifa is an important port city in the north of Israel. So, this is North Israel, important port. That is north of Israel. Now, when we talk about the middle of Israel, there's another port that is Ashdod. Ashdod is a major port in the middle. Now, Tel Aviv. Tel Aviv is also seen as a capital, yes. But Israel says that my capital is Jerusalem. But many countries do not recognize Jerusalem as the capital of Israel. They see Tel Aviv as the capital of Israel. Now, Tel Aviv. But Tel Aviv is also a port city, can also be seen as the capital of Israel, officially recognized by many countries in the world. Ashdod. And there's one more port at the bottom, the south of Israel, Elat. And that we discussed yesterday also, Gulf of Aqaba or Gulf of Elat. Now, in the southern part of Israel is the Negev Desert. Negev Desert. So now, first of all, the UPSC asks about cities or the ports, which of the following ports belong to which of the following countries. The major ports of Israel is the Haifa port in the north, Ashdod port in the middle, and the Elat port in the southern part of the Israel. Now, opening up into Gulf of Aqaba. Now, so the Dead Sea, you can easily see the Jordan River coming from north to south, Sea of Galilee, and again that another name of Sea of Galilee is Lake Tiberias. Now, when we are moving this, yes, in the bordering areas, yes, the Golan Heights is again occupied by Israel, but still the official part of Syria. Now, West Bank, Gaza Strip, Sinai Peninsula that we discussed yesterday, Jordan. So hence, when you talk about Israel, it is bounded north by Lebanon. So again, let's see. So this is Lebanon, north by Lebanon. Okay. To the northeast by Syria, you already know. Northeast by Syria, Golan Heights, you can connect. Southeast by Jordan, yes. So Jordan River forms the boundary. And to southwest by Egypt, that is the Sinai Peninsula. And west to the Mediterranean. Yes, please. Hello. Is somebody speaking? Okay. Now, so traffic voice is coming. Who is traveling? Who is traveling here? Okay. Jerusalem is the seat of the government and proclaimed capital. So proclaimed by Israel. Although the later status has not been received wide international recognition. So Jerusalem is proclaimed. Anyone who is ultimately creating disturbance, so please mute yourself. Otherwise, I have to mute everyone.
दूसरी जिंदगी लेके आ रहा है जिंदगी 2.0
अरे कोई मूवी देख के आ रहा है?
Sir, it's Shami.
So now everyone is muted. Yes, so now raise your hand, I will unmute. Okay, now, so Israel we are talking about. So how many cities you remember now? How many port cities? Haifa, Ashdod, okay, Elat, and also Tel Aviv. Jerusalem is the proclaimed capital, but not widely recognized capital by the international community. Now we know north is Lebanon, then Syria, then Jordan, okay, Sinai Peninsula means Egypt, and opening up to the Mediterranean Sea. Elat port is opening to Gulf of Aqaba. Okay, Jordan River, Sea of Galilee, okay, also known as Lake Tiberias. So a small for a country, but having so many important locations that you have to remember. Now, Israel has got 4 geographic locations. Mediterranean coastal plains, so touching the Mediterranean Sea. Hilly regions of the north, that is touching the Sea of Galilee or the Golan Heights. Great Rift Valley, which again crossing the north to south of Israel, and the Negev Desert in the southern Israel. So the principal drainage systems we know: Lake Tiberias, also known as the Sea of Galilee, and the Jordan River. These are the major sources of water. And yes, we discussed important ports: Haifa, Elat, Ashdod, and Tel Aviv are the major ports. Are the major ports of Israel. Now, another thing which is coming into picture is the possible creation of a Ben Gurion Canal. Now, what is a Ben Gurion Canal? So we know Suez Canal is dominated by Egypt. Now, so Israel is searching for an alternative, so as to reduce the Egypt's hegemony on Suez Canal by creating an alternative route through Gulf of Aqaba and then via Israel touching the Mediterranean Sea. So now, it was in 1960s that the Ben Gurion Canal project was conceptualized as a transformative infrastructure initiative. It is named after Israel's founding father, that is David Ben Gurion. So Ben Gurion Canal. So it's around 160 miles. Let's see the map. So here's Gulf of Aqaba. So that is supposed to be crossing Israel via this, and then finally to Ashkelon, entering into Mediterranean Sea. So hence it aims to create an alternative maritime route connecting the Red Sea with the Mediterranean, thus bypassing the Suez Canal. Now what is the locations in picture? So it's the area Gulf of Aqaba till the Mediterranean coast. Friends, it's proposed to be cut through a canal via the Negev Desert. So here is the Negev Desert, the southern Israel, starting from Gulf of Aqaba, extend to the eastern Mediterranean coast. And the Gulf of Aqaba has a coastline shared by 4 countries we know: Egypt, Israel, Jordan, and Saudi Arabia. Now, what are the economic implications? It will create a new shipping route between Europe and Asia, bypassing Suez Canal and reducing Egypt's control over global shipping. This is the perspective. This is the perspective. This is very clear. Gulf of Aqaba, crossing the Negev Desert, entering into Mediterranean Sea, is a planned project that is called Ben Gurion Canal. We are supposed to provide an alternative to Suez Canal. Ben Gurion. Now, Lebanon. Lebanon is also a very important country, always in news, always in the news with respect to the clashes, okay, and is also a very volatile country. Now, so Lebanon is about north of Israel. So when we talk about Lebanon, again, a very small country, is half the size of Israel. If Israel is 20,000 square kilometer, Lebanon is only 10,000 square kilometer. So it's a very small country. So Lebanon is a country located on the eastern shore of Mediterranean Sea. Again, eastern shore of Mediterranean Sea. Is bounded to the north and east by Syria. So here comes Syria. So north and east by Syria, and south by Israel. So which are the 2 bordering countries? The 2 bordering countries are Syria and Israel. Syria and Israel. Now there are 2 mountain ranges. One is the Lebanon mountains from north to south, and there's also the parallel ones is anti-Lebanon mountains. And anti-Lebanon mountains form the border between Lebanon and Syria. So now anti-Lebanon mountain range forms the long stretches of border between Lebanon and Syria. The country also shares maritime border with Cyprus. Now, land borders with Syria and Israel, and maritime or the border through Mediterranean Sea with Cyprus also. Now, which are the important cities and ports visible? Important city and port visible is Tripoli. Then comes the capital Beirut. Another port that comes into the picture is Sidon and Tyre. So these are 4 ports again: Tripoli, Beirut, Sidon, and Tyre. So these are the 4 major ports here in Lebanon. Now, why this is a very volatile country? Because of the mix of different communities and religions and population. It is always in what flux. So Lebanon comprises of Shia Muslims, a substantial population, Sunni Muslims, a substantial population, Christians also, and Druze. And who are Druze actually? So, for example, in India, there are Sikh. So Sikh ultimately brings the religious preachings of both the Hindus and Islam. Yes. Okay. Similarly, Druze are the set of people who brings what the religious preaching both from Islam and Christianity. Okay, as a separate sect. So now, so that's why with the composition of population, this is always in flux, and definitely it has got is at war with Israel. You must have heard about a militia by the name Hezbollah. So Hezbollah base is in what? Southern Lebanon. Hezbollah base in what? Southern Lebanon. Hezbollah is in southern Lebanon. So it's the Shia militia. So Lebanon is to the north of Israel and to the east and to the west of Syria, and Mediterranean Sea, the coast, and the major cities are Tripoli, Beirut, okay, Tyre, and Sidon. And the two mountains ranges, Lebanon and anti-Lebanon. And anti-Lebanon is a border between, creates a border between Lebanon and Syria. So these are information about the Lebanon. Now, map of Syria. Now let's talk about Syria again. Syria. So this is Syria. So we have discussed Israel. We have discussed Lebanon. Now let's talk about Syria. Now again, there was again an airstrike by Israel recently deep into Syria. And again, there are certain cities which are very important, asked by UPSC previously also. For example, cities like Aleppo, important city. Then Raqqa, Idlib, Homs. Now, is an important city, Idlib, Damascus. Okay, sorry, this is not a city in what Syria. Karbala may be in Iraq, yes. Now, the important port here to note is Latakia port. So hence, very, very important to remember the ports of different countries. So can you name what is the port of Jordan? Can you name the port of Jordan? Anyone? Okay, so let me unmute. Raise your hand if you want to speak. Port of Jordan, anyone? Yes, Shilpi? Okay, just a minute. Afia, you can speak. Okay, you can unmute yourself. I have unmuted.
Aqaba.
Support of Aqaba.
Port of Aqaba. Okay, and which is the nearby port of Israel to Aqaba? Which is the nearby port of Israel to Aqaba?
Elliot, sir.
Elat. Yes, E-I-L-A-T.
Elat.
So that's why they are termed alternatively Gulf of Aqaba and Gulf of Elat. And Gulf of Elat and Aqaba is the northernmost reach of what? Coral reefs. Okay. Now, can you name the port of what? Lebanon? Any one port of Lebanon?
Beirut, sir.
Beirut is the capital, you may be knowing, but besides Beirut?
Tripoli.
Tripoli, yes. And Sidon and Tyre. You know?
Yes, sir.
Okay. Israel, the major ports? Akash?
So
Okay, which is the northernmost port in Israel?
Haifa, sir.
Haifa. Okay, which is in the middle of Israel?
Tel Aviv.
Tel Aviv and Ashdod. You know?
Ashdod.
Okay. Okay, and what is the another name for Sea of Galilee?
Lake.
Lake Tiberias. Okay. Okay. So, okay. So let me put a statement now. Let me put a statement.
So Lake Tiberias is another name.
Lebanon lies to the east of Syria. Is this right or wrong? Lebanon lies to the east of Syria.
False.
False. Okay. 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 So Golan Heights, yes, Golan Heights lies to the east of Israel.
yes, sir.
Yes, sir.
Yes. Good. Good.
It should be, sir, north.
Yes. Yes. You want to say something?
It should be northeast, right?
Northeast. Northeast of Israel. Yes. It's
Yes.
not on the western side, but definitely northeast side.
Yes.
Okay, now, so what we are seeing important cities of what is Syria now. So Aleppo, Idlib, but here the important port, Latakia is a very important port of Syria, Latakia. So another port to be read and remembered is Latakia port. Now, so which are the bordering countries? Let's see. So Turkey at the north, Turkey at the north, then Iraq, Iraq to the east, Lebanon to the west, and Jordan and Israel to the southern part. So 5 neighboring countries, Israel, Lebanon, Jordan, Iraq, and Turkey. Which is the major river flowing through this? Euphrates River. So Euphrates River, which originates in Turkey, passes through Syria, and then through Iraq, that ends where in Persian Gulf, Euphrates. So now let's see again in detail. So Syria is bounded by Turkey to the north, Iraq to the east and southeast, Jordan to the south, and Lebanon is right to the southwest. Major river is Euphrates River, most important source of water. Originates where? Turkey, and it flows southeast towards the eastern part of Syria. There's a dam in Syria that's called Euphrates Dam, which creates an artificial lake that is called Lake Al-Asad, which creates an artificial lake called Lake Al-Asad. Okay. So let's see Lake Al-Asad again. So here, this is Lake Al-Asad in the northern part of Syria. So it's through the dam created by Euphrates River. The dam is also known as Euphrates Dam. Now, let's see more. Now, let's see Iraq. Now, Iraq was again asked in UPSC 3-4 years back with respect to those cities. Okay, Mosul, yes. Mosul is a city. Erbil was asked by Israel. Oh, sorry, by UPSC. So, Mosul, northern Iraq, Erbil, Kirkuk. These are the major cities. Yes, Karbala is a city in Iraq. So, I wrongly put it there. And Basra is the southernmost city. Basra. Now there's a Doab, yes. So there's a Doab, so which is comprising of Euphrates and Tigris. This is the Doab area. That is the merging of 2 rivers. So Basra is a city which is at the junction of what? Euphrates and Tigris. So cities to note are Mosul, Kirkuk, and you can add on Erbil in the north. Baghdad is the capital in the center. Baghdad is on what? Which river? Tigris River. Baghdad is on Tigris River. Karbala, Najaf, and Basra. Basra is the southernmost. So Iraq is the country of southwestern Asia, bordered to the north by Turkey, east by Iran, and west by Syria and Jordan. South by Saudi Arabia and Kuwait. Iraq has a coastline also, where it's opening up in Persian Gulf. Opening up in Persian Gulf. Not a very big. So when I talk about Jordan, has got a very small coastline. When I talk about even Iraq has got a very small coastline. I told you yesterday, Jordan is not a landlocked country. It has got a small opening in Gulf of Aqaba through Aqaba port. And now when you see the entire Middle East map, yes, it looks like this. So Middle East map. So now, which are the countries that we have discussed? Yes, Syria we have discussed. Okay. To the west of Syria is Lebanon. Lebanon we have discussed. Okay. To the east of southwest of Syria is Israel. We have discussed. Jordan. This is the Sinai Peninsula of Egypt. Now, Iraq we discussed. These are the major. So how many countries you discussed in detail? Jordan, Lebanon, Israel, Syria, and Iraq we have discussed. Okay. So now, first of all, you're supposed to revise all these locations which we have discussed. Gradually, we'll be opening up more countries on day-to-day basis. So I hope this is enough revision for today. Now, tomorrow, most probably, we'll be starting the international issues. Yes, international issues is starting tomorrow. And maybe 2-3 agency will discuss tomorrow also. NIA will discuss, National Investigation Agency. and CVC also, Chief Vigilance Commission. And after doing this, we'll be studying international issues, international current affairs. Again, followed by various locations in news. Yes, Akash, you can say.
Sir, I have few doubts, sir. Sir, why we are saying it the lake when we are saying it the Sea of Galilee?
Sea of Galilee. Lake. So for them, it looks like a very big water body. For a small country, it looks a very big water body. So they feel that we are ultimately living besides a sea, not a lake.
And
the same doubt, Bhumika. Okay.
And sir, what was the length of that Ben Gurion Canal?
For example, Caspian Sea. Caspian Sea is also a lake. But Caspian Sea is really huge lake, which can be equated with a huge water body like sea. But very small country of Israel, which can be hardly 20,000 square kilometer. If there's a lake like Dead Sea, which is also a lake, Sea of Galilee is also a lake. But if you see, if a country of 20,000 square kilometer has got a lake of area of around 600 square kilometer, that looks very huge. Okay, for them, that gives a feeling of sea for them, but actually they are lakes.
And sir, what was that length of Ben Gurion Canal?
Ben Gurion around 160 miles proposed, 160 miles. And
sir, we used to read a term called Babylonia. So where it is situated?
Pardon?
Sir, Babylonia. We used to
Babylonia. Babylonia is ancient Iraq. Yes. Okay. Mesopotamia is also known as Mesopotamia also. Babylonia means Iraq and certain parts of Syria. Yes.
And sir, when we were discussing about that CBI, sir, you said something about PMO relation with the CBI. What was that? I didn't get.
PMO relation with?
CBI.
CBI.
Yes.
The CBI is under DOPT and DOPT is under PMO.
DOPT is under PMO. Yes.
Okay, that way it is related to
that's why it's related to PMO.
And sir, somebody is asking about that mutual consent of that was withdrawn for some states have withdrawn for the CBI. So, for example, West Bengal. So CBI cannot directly go and arrest somebody or
no. Yes, it has to ultimately take the permission. Yes.
From the High Court.
Yes, from the High Court.
And sir, while you were telling about the central jail, so why the name is central then when it is situated in a district?
See, central jail for a particular area. Yes, it's the main jail of a particular area. That's why it's central jail.
Okay. And then, while discussing about the interim bail, there was a sentence in which it was that interim bail can be prolonged.
Prolonged means it can be extended till the time the regular bail is being given.
But you said it is issued only for a few days.
It can be a few days, but again, if that expiry of the date is coming near and still a regular bail is pending, then the person can again give me what additional days as interim bail. That can be extended.
And sir, there was also some statement where it was for 90 days and you said it can be extended till 180 days.
180 days in the cases of UAPA cases, in the cases of narcotics case, it can be extended till that.
Okay. Thank you, sir. Thank you.
Okay. Yes, Sai.
So I had a doubt regarding yesterday's class about the electoral rolls. In that, so there was an amendment, and based on which there was a provision of 4 qualifying dates to enroll as a voter in a year. Can you just elaborate?
Yes. Speak. Your voice is not coming. Yes, 4 qualifying dates.
So can you explain a little bit? I got a little confused with that provision.
4 qualifying dates means at least it depends. Yes, it depends on the election commission to fix those qualifying dates. For example, in each and every year, as we know, certain people will be turning adults. Okay, so there's a requirement about including them in electoral roll. So certain windows are being opened. Those windows, there can be those qualifying dates that can be put by election commission as per the requirement. That can be on 3 monthly basis. There can be a qualifying window which can be opened. Now, with respect to the forthcoming general election, the last window that was opened was 1st of January 2024.
Understood, sir. Thank you.
Okay. So I hope the things are very clear with all of you. Let me see if anything remaining in the chat with respect to any query. So see, Muskan, with respect to CBI code, It's the state government. Is the state government. If there's a requirement of a larger number of cases to be handled within the state, the state government can be giving a permission to create a court, yes, equivalent to a district court. The state government. Okay, so I hope this is a fine revision for all of you. Let's resume the class tomorrow with more international topics tomorrow. So thank you. Let's resume the class tomorrow. Thank you.
Thank you, sir. Thank you.
Thank you, sir.